Good morning. Welcome to the Minnesota Association of Realtors e-resource. Today we're going to be discussing an issue that a lot of you have been contacting us about. It has to do with sellers mandating the use of a specific lender or a specific title company when closing a transaction. Sellers will often put this information in the purchase agreement, stating something like, the buyer agrees to use company X, Y, or Z, generally just one of them, in order to purchase this property for either their lending needs or their title needs. Today we have a memorandum from Don Smith and Brad Boyd, our legal counsel with Thomsen Nybeck. They've been researching this issue over the last few weeks and have come up with a memorandum that we think you should download from our website and read fully. It is 3 pages long, and I'll try and highlight the most poignant parts today. The first part is, can a seller require a buyer to use a particular title company or mortgage lender? And the second part is, what about incentives or disincentives that a seller may put in place, including paying for the seller's closing costs, including real estate commission if the buyer doesn't use the seller-specific lender? Question 1 is that a seller can seek to require use of a particular lender or title company, and the buyer can reject those terms in the purchase agreement. Purchase agreements, as you know, are a negotiation between the buyer and the seller. So on its face, there's nothing wrong with the seller putting out there that we would like to have the buyer use company A for their mortgage and company B for their title work, because perhaps the seller has confidence they'll be able to get that done. There is one large RESPA, Real Estate Settlement and Procedures Act, exception to that. And RESPA says that if the seller has an affiliated arrangement, meaning a affiliated relationship, they're paid for, they're a stockholder, something like that, if they have a affiliated business relationship with the mortgage lender or with the title company, and it involves a federally chartered mortgage, Fannie Mae, Freddie Mac, HUD, VA, the vast majority of the loans that we're going to deal with, then they are not allowed to do that. So they may not require the use of a lender or a title company if the loan involves a federally related firm. If the seller does require that, the buyer should inquire of the seller whether or not they have an affiliated relationship. That is very important. If there is no affiliated business relationship between the seller and there is no business relationship between them and the title company, and the lender would pay a referral fee, this may be a RESPA violation, and that is something that the seller should look into, or the seller's representative. As I've said, title companies are the same there for those. Also, if you're dealing with an unaffiliated title insurance, RESPA specifically prohibits a seller from requiring a buyer to purchase title insurance from a particular provider. So RESPA then, the Real Estate Settlement and Procedures Act, steps in. Courts have ruled, however, that if a seller pays for the buyer's title work, that does not interfere. So let's say you've got a purchase agreement and the seller says, I'm willing to pay for the buyer's title insurance policy. Then the seller gets to select who that title company is, because the seller is paying for it, not the buyer. So that's an important caveat. There is also no RESPA violation if a referral fee is paid by the seller. Closing companies in Minnesota fall under another statute, and because title companies in Minnesota also fall under closing companies, it has a restriction on builders and financial institutions, as well as a few other certain parties, that they cannot direct who the buyer uses. That's an important provision that you need to understand, is that in Minnesota we have an additional provision. Title companies serve as closing companies, and agents may want to direct builders or financial institutes to this statute, and we do have that online for you on the slideshow. So just kind of a recap of the entire program for you today. If the buyer is purchasing property with a federally related mortgage, A seller may not require a buyer to use a specific title company or mortgage lender when the seller has an affiliated relationship with either the title company or the mortgage lender. A seller can seek to require the buyer to use a specific title company or mortgage lender when there is no federally related mortgage involved in the transaction. However, it is subject to Minnesota statutes 507.45, and you should be aware of that, as well as a RESPA violation if there is a referral fee paid. If there is no affiliated relationship between the seller and the mortgage lender, there is no specific prohibition against the seller requiring the buyer to use a particular mortgage lender unless a referral fee is paid to the seller, of which a possible RESPA violation occurs. We hope that you'll download this. This is an important issue. We have told Thomsen Nybeck that this will be online on Tuesday morning for most of the agents and brokers, so that you may be calling in. Please be patient, review the documents, and we hope that you have a great week. Thank you.